Hello, welcome to my channel. My name is Katie and you are joining me for my series on the trial of Kouri Richins, who has been accused of murdering her husband Eric Richins by poisoning him with fentanyl. As of right now, she is in jail with no bail, but presumed innocent. Whereas today we are going to go through the motion to enforce the gag order, because if you've watched any of my previous videos, we went through that jailhouse letter. It says on the top, walk the dog. Kouri says it is notes for an upcoming novel. The prosecution says it's witness tampering. So the defense are saying that the prosecution should have never released it because it's attorney-client privilege, because as we saw in a previous video, it was in an envelope that was marked for her lawyer, allegedly. But today it's just going to be, oh, there it is, as you can see, the motion to enforce order and for contempt sanctions. Let's have a look-see. So, they never date these things, by the way. It's really annoying. But, State of Utah versus Kouri Richins. Defendant Kouri, through her counsel, moves this court to enforce the gag order, which was entered on the 2nd of June, for contempt sanctions. On the 31st of May this year, the state filed a motion of a gag order. The state filed it? Oh. Claiming that its requested relief was necessary to prevent tainting of the jury pool and to protect Miss Richins' rights to a fair trial. In response to the state's motion, on the 2nd of June, the court entered an order requiring compliance with the Utah rules of professional conduct, i.e. the gag order. The gag order prohibits the lawyers in this case from making an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Apologies, someone has decided to do their gardening. Apologies if you can hear that. Nevertheless, September the 15th, the state filed a document titled Walk the Dog Letter on the public docket in this case. Notably, the Walk the Dog letter was not filed as an exhibit to a motion or pleading, nor was it filed pursuant to any rule of civil or criminal procedure. Instead, it was an extrajudicial statement made for the apparent purposes of influencing the court of public opinion. Such behaviour constitutes a blatant violation of the gag order entered on the 2nd of June, which the state requested, as rightly they point out, because I didn't know they requested it, the state. I assumed her defence did, but am I in the middle? There I am. Okay. Because there can be no doubt the state knew about the gag order, had the ability to comply with the gag order, and willfully refused to do so, the court should find defendant in contempt and impose appropriate actions. Are they referring to the state as the defendant in this particular piece of paper? Ugh, I need a law nerd. Okay. On 31st of May, the state filed a motion for a gag order to prevent tainting of the jury pool, protecting Richins' rights to a fair trial. And the motion states the Summit County Attorney's Office takes its responsibility to protect the integrity of the criminal justice process very seriously. This case should be tried in a court of law on the basis of relevant and admissible evidence, not in the court of public opinion on the basis of uninformed or inaccurate sensation, rumour and hearsay solicited from persons with incomplete knowledge of the circumstances and evidence of the alleged crime. To be off topic, I am only saying what they publish. I'm not giving anything else. Just cover my own back, even though I'm in a different country. So, in this case, observation of the defendant's presumption of innocence and protection against pre-trial tainting of the jury pool should be paramount. Furthermore, at the centre of this matter are 3 minor children belonging to Eric and Kouri. The children should be shielded to the greatest extent possible from the glare of untimely publicity. And I have been saying that myself, that we have to keep in mind that there are children involved. I don't like the idea that they belong to parents. I suppose technically, legally they do. Okay, in response to the state's motion on the 2nd of June, the court entered an order requiring compliance of the gag order. Among other things, the gag order prohibits the lawyers in this case from making an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Why do they use so it's legalese? Why? Do it in English or whatever language you naturally speak. No one naturally speaks legalese. Anywho, sorry. Despite the plain language of the gag order, on 15th September, the state filed a document titled Walk the Dog Letter on the public docket in this case. So could they have filed it in the private docket? Does anyone know? I have no idea. As the state noted in its motion, the public docket is followed closely by both local and global media outlets. Hi. The Summit County Attorney's Office has been contacted by numerous global media outlets, and then it lists all of them. I have not. I thought about it, but then I thought that no one's going to talk to me. And at least 4 filmmaking organisations in America and in Western Europe have expressed their intent to produce a documentary. A quick Google search reveals that exponentially more media outlets have already reported on this matter. In addition to the outlets listed above, these include but are not limited to, and then they list everyone. This in the first weeks after the matter was filed. The state did not file the Walk the Dog letter pursuant to any rule of civil or criminal procedure. Further, it appears the state obtained the Walk the Dog letter through a potentially illegal search of Miss Richins' documents, which were stored in an envelope titled Sky Lazaro Attorney Privilege. And we've seen that envelope before. The Summit County Sheriff's Office Custody Manual includes a clear limitation on the search of legal documents. The manual provides that legal pouches may only be inspected to determine whether the pouch is being used to hide contraband. A letter is not contraband. The state has knowingly violated this court's gag order issued on the 2nd of June, and sanctions are appropriate. The court's authority to sanction contemptuous conduct is both statutory and inherent, and then there's lots of, I assume, references to different laws or cases. It has always been held, regardless of express statutory authority, that courts of general jurisdiction have the inherent power to make and enforce all necessary rules and orders calculated to enforce the orderly conduct of their business and secure justice between parties litigant. If someone could translate that for me, that would be great. As to the court's statutory authority, Utah Code identifies certain types of acts or omissions in respect to a court or its proceedings that are contempts of the authority of the court. One such category of contempt is disobedience of any lawful judgment, order, or process of the court. Another category of contempt is deceit or abuse of the process or proceedings of the court. If contempt is established, the court may impose a fine not exceeding $1,000, order the person incarcerated in the county jail not exceeding 30 days, or both. Contempt sanctions may be calculated separately for each violation of a court's order. The trial court acted within its discretion in sentencing defendants separately for each violation. To establish contempt, 3 elements must be proven. Number 1, let me just shuffle in my chair, apologies. Number 1, that the person cited for contempt knew what was required. Number 2, that the person had the ability to comply. And number 3, that the person intentionally failed or refused to do so. All 3 elements are easily established here. After hearing on the state's motion for gag order, the court issued its June the 2nd gag order. The gag order states in relevant parts: lawyers who have participated or who are participating or who will participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. Among other provisions, Rule 3.6 prohibits a lawyer from making an extrajudicial statement that the lawyer knows or reasonable should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. You enjoying my translation? Sorry. Okay. The state has violated this order and the appropriate sanctions should be imposed. Ironically, the state has done precisely what it asked the court to disallow and what the defence has objected to on more than one occasion. On the 31st of May, the state filed a motion for a gag order claiming that its requested relief was necessary to prevent tainting of the jury pool and to protect Ms. Richins' rights to a fair trial. In response to the state's motion, on the 2nd of June, the court entered the order which requires compliance with all the rules. The gag order prohibits the lawyers in this case from making an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing. We've said that sentence before. Notwithstanding the 15th of September, the state filed the Walk the Dog letter on the public docket in this case. This letter was not filed as an exhibit to a motion or pleading, nor was it filed pursuant to any rule of civil or criminal procedure. This filing further disregarded the parties' stipulation to produce documents in a specific, orderly and formal manner as outlined and agreed upon during the June 30th hearing. Oh, so they're saying not only should you not have done it, you also ain't done it right. The state's filing was improper on several fronts. The filing is an extrajudicial statement made for the apparent purpose of influencing the court with public opinion, which, to be fair, it kind of did. Such behaviour is a blatant violation of the gag order, which the state requested in the first instance. The state's intention was to improperly file the letter to taint the media, the jury pool, the public narrative, and has the added consequence of potentially tainting expected witnesses in this matter. This filing was the logical equivalent of sending directly to the media or posting it online. Within minutes of the filing, media outlets were reaching out to defence counsel for comment. This demonstrates the desired effect that the state intended. It is made clear by its conduct that the state is indeed not concerned with the tainting of the jury pool and protecting Miss Richins' right to a fair trial, as it outlined in its motion for the gag order. Rather, it is concerned with winning at any cost, irrespective of the rules and orders that govern the proper administration and procedure in criminal proceedings. Notably, earlier this afternoon, on September the 15th, the state also filed a motion for no contact order. One of its assertions is that to protect the integrity of this proceeding, it is imperative that the defendant have not contact with Lisa Darden or Ronald Darden. Firstly, can people spell check and just generally check before they do these things? Because that made no sense. That the defendant have no contact, sorry. More importantly, to protect the integrity of this proceeding, the state must discontinue its improper behaviour and disregard for the applicable governing law and orders in this matter. In addition to the issues surrounding the retrieval of the document in the first instance and the state's improper filings on September the 15th, the state's motion for no contact order wholly misconstrues the contents of the letter and alleges witness tampering without a legitimate or good faith basis. Oh, okay, we're going to stop there. A good faith basis. I personally, if I have, we've seen the letter, it don't look good. Everyone thinks it's alleged witness tampering. But then again, should they have released it? Probably not. Further, there is no evidence that Miss Richins has ever done anything with the letter in question. Well, she didn't get a chance. In my opinion. Miss Richins' mother never received the letter. Likewise, as related to any other letters that the state refers to, there is nothing improper or illegal about writing something down and sharing it. The state presents no evidence at all that Miss Richins has destroyed or flushed letters and uses this basis, or lack thereof, to attempt to reach beyond the bounds of law. So they're saying she's been writing letters and flushing them down the toilet. Well, what's the point in writing a letter if you're just going to flush it? And what evidence do they have? Did they go down the toilet? Ugh. Ugh. There is no evidence that Miss Richins' witness tampered or that any information was conveyed to Lisa or Ronald. Miss Richins retains and reserves her right to file any necessary motions or responsive pleadings, such as motions to suppress or otherwise as related to the state's recent filings. As an important and related aside, since the outset of this case, the state has engaged in improper conduct related to the dissemination and production of private records and information. For instance, on the 28th of May, the state filed and disseminated sensitive information that should have been classified as private. The state then initiated text message correspondence with Honourable Judge Mrazik to retroactively address the issue. Yes, it might say it, but there's a text message conversation at the bottom of here. We might have a rummage through that. On the 1st of June, the State and Defence Counsel shared email correspondence wherein the Defence Counsel explained that the prosecution had produced and filed an exhibit which contained several unredacted pages of not only Miss Richins' social security number, but also the joint bank account number, and that was a violation of the rule, which designates such information as private. Well, yeah, social security numbers and bank account details, that should be redacted. Even I know that, and I have no qualifications. Defence Counsel went on to make clear that this seems to be a recurring problem. Please take the necessary steps to immediately have such information classified as private and confidential and removed from the public docket in the current filing, as well as all future filings. These are only a few examples. So hang on, are the prosecution blaming the court? No. It was okay. The defence are blaming the prosecution. Okay. Despite this historical pattern from the prosecution, the state has continued to engage in such conduct. Namely, on the 15th of September, the state filed a subpoena and notice of return of service for records and information from Park City Medical Centre. The subpoena again included the defendant's social security number. Clearly, private information should not be publicly disclosed or filed. The defence has addressed this behaviour on multiple occasions. Notwithstanding, the state has again done precisely what it asked the court to disallow, and what the defence has specifically objected to on countless occasions, including previous hearings. The state's text message to the judge on the 28th of May exemplifies that it is acutely aware of the impropriety of publicly filing and disclosing private information, as it went out of its way to contact the court on a Sunday to request to seal the private document that it had improperly disseminated. This is a big case. The prosecution needs to step up and do things properly, in my opinion. The defence's position is that the behaviour violates various rules. A certain rule permits the court, on its own initiative, to enter an order describing the specific conduct that appears to violation and directing an attorney, law firm or party to show cause why it has not violated with respect. The court's conduct is worthy of contempt and sanctions. Do you mean the state? I don't blame in the court. Doesn't sound right. Conclusion. For the foregoing reasons, the court should issue any and all appropriate contempt sanctions, including but not limited to striking the walk the dog letter from the docket, or in the alternative designating it as a private record, and reasonable attorney's fees incurred in bringing this motion. Well, if you want to see the walk the dog letter, there will be a link in the description once this video is finished, where you can see it. It's in the public domain now. Too late. So, this is a motion to enforce the gag order, signed electronically. Exhibit A, I think. Was this the original? This was the original gag order. And here it mentions Koberger. That's how big that case will be, that it's actually already being referred to in legal documents, and it hasn't even gone to court proper yet. So this is why they're asking for the gag order. So the attorney's office has been contacted by various media peoples, and they've done a quick Google search. Hi, might find me. There's been people camped outside the court and the attorney's office asking questions about Kouri, and they've been asking key witnesses to give statements. Oh, like, it's nasty. And the defendant's jail calls reveal that she has been communicating with a documentary filmmaker directly and through a friend. Okay. Blah, blah, blah. That's what they can do. Blah, 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 blah. Boring. Boring legal stuff. Boring legal stuff. This is brilliant for TV, isn't it? Okay. Argument for a gag order put forward by the prosecution, and they are breaking their own gag order. Although I must say, the prosecution have said that they have not broken any gag orders or any rules by releasing that letter. So, we shall see. This press release. Now, what was Exhibit B? And yet, that is the order saying yes, stop talking about it. And it was filed and electronically signed. This was the letter. Let me zoom out. Ooh. Here we go. Sky attorney privilege. Now, when was that put in the letter? Envelope. When was that put in the envelope? Call me a cynic. Zoom back into Exhibit D. Ooh. You're getting seasick by watching all this, I wouldn't be surprised. This is the text message conversation that they mentioned. 5 people in the group chat. Dear Judge, do 2 search warrants have just been filed, but it's gone into the public bit. Please check. Sky, the defence lawyer, is on the text. Oof. Like, oof. You gotta, like, message the judge on a Sunday. I doubt that's gonna go well. After reviewing your filing, we realised that the exhibit contains several unredacted pages, including Kouri's social security number, joint bank account, Utah Code of Judicial Administration designates such information as private. This seems to be a recurring problem. Please take the necessary steps to immediately have such information classified as private and confidential and removed from the public docket in the current filing as well as future filings. And that is from Sky to everyone. Oh, she told them. Okay. So, there you go. So, yeah, that's fun. Can you imagine? Like, they have filed the gag order, as in the prosecution. And everyone's gone, yeah, cool, fine, we agree. And then it's the prosecution that allegedly break it. Allegedly. But this case has actually gone quiet since I last updated, which makes a nice change because I haven't been that well. And I was thinking, oh no, there's going to be like 5 stories at least when I come back. But no, the girl has kept her mouth shut. She's sat on her hands, thankfully. She's due in court again on the 3rd of November. I'll be covering it. We'll see what's going on. If you're interested in this case, I do have a whole playlist. Please go see. And if you enjoy my content, like, comment, subscribe, share, all the YouTubey things. This one was a bit of a long one. We actually went through a whole document. I don't normally do that. We normally just go by whatever's on some website, like a good website, but some website. So yeah, let me know what you think of this style, going through documents, actually like line by line. If you enjoy it, let me know in the comments. If you don't, let me know in the comments. But what do you think about this? Did they break their own gag order? What do you reckon? I think they probably did, especially if it was in that envelope that said attorney-client privilege thing. But that's it. Thank you for watching. I will let you get back to your day. I think that's it. Love you. Bye. Mwah.